Good afternoon. We're just going to let everybody in. All right. Well, good afternoon. On the behalf of the Law Society of Nunavut, I'd like to welcome you to this continuing legal education presentation. Many thanks to John McLean, who is Senior Legal Counsel for the Government of Nunavut, and also Jennifer King, who's partner with Gowling WLG, for providing this CLE presentation. It will be recorded and posted on our website afterwards. There will be an opportunity to ask questions at the end, but we'd like you to please save your questions for the end so that the presenters can get through their presentation. And if you do have questions in the interim, you can also put them in the chat so you don't forget them in the meantime. Without further ado, many thanks again to John and to Jennifer, and I will turn the floor over to you.
Well, thank you, and good afternoon, everybody out there online joining us. Some of you may have attended a presentation I presented a couple of years ago on emergency laws in Nunavut. This is kind of an update, given that there have been some case law developments in the intervening years. The Supreme Court of Canada has opined, as is the federal court and other trial level courts. Jen is a partner at Gowling WLG, also a member of the Nunavut Bar. I, of course, have been with the GN for almost 16 years and am a past president of the Law Society of Nunavut. But both of us practice in this area. Both of us have appeared in court on these matters. So we were talking together about what could we do in terms of a continuing education that we share in common. And this is the one that came up. So welcome. And we have a tight hour for you today. And we're trying to keep it as go as quickly as we can over the review and then get so we can really talk about the cases. So, and because we're lawyers, we're required to give you a disclaimer. The information in this presentation is intended for educational use, is not for legal advice, and our opinions are our own and not necessarily those of our employers. Disclaimer out of the way. So why don't you take us through our outline?
So we're going to cover kind of four buckets today. John's going to give a refresher on his presentation with respect to the emergency legislation in Nunavut, but we're going to keep, I think everyone's going to have access to the slides afterwards, and I think he's going to skip over quite a bit of it that you can refer to though in the presentation. We're then going to take some time, some good time on three major decisions that have come out since John's last presentation at the different levels of the court on essentially how the courts have been dealing with reviewing government action in emergencies. We're going to take some time to talk about a case that's a couple years older that talks about some of the considerations about Indigenous rights and the duty to consult when governments are planning for emergencies. And then we're going to talk about a couple of case studies that are relevant to the North.
Okay. So an overview of our emergency legislation. So, of course, remember your federalism because it never goes away. Emergency law space affects areas of both federal and territorial jurisdiction. My slides are going to be mostly about the territorial legislation, and that's your Emergency Measures Act, which are the things that handle your civil emergencies, our Public Health Act. Those of us who've been through the pandemic remember how that works, but we're going to go through that today. And that's primarily what I'm going to be talking about. But the federal legislation also is going to come up, and it's going to come in some of the cases we're talking about today. So the Emergencies Act, it's only been ever proclaimed once for a public order emergency during the pandemic. But the Quarantine Act is once again in the news because Ebola in Africa and the hantavirus outbreak on the MV Hondius cruise ship. So federal government is responsible for quarantine upon entry into Canada. So the Quarantine Act, you have been subject to this every time you've crossed a border without necessarily knowing that you have, because every Canada Border Services agent is authorized as a quarantine officer. So anybody coming from source countries is subject to a medical investigation and quarantine under that act. And if you are asking, does Nunavut have a plan to deal with Ebola? The answer is yes. And it involves medevacing people to larger provinces as quickly as possible, because we do not have the facilities to isolate effectively somebody with that kind of a disease. So we get them on a medevac plane as quickly as possible, should it happen. But that's all I'm really going to say about quarantine today. So, what's an emergency in our legislation? It's any present or imminent situation that is seriously affecting or could seriously affect the health, safety, or welfare of persons, or substantially damaging or could substantially damage property. And in the examples for us, if you've lived in the north, you've experienced any or all of the following. So natural disasters, floods, severe storms, and wildfires. We actually, because the pandemic was weird, Nunavut, which doesn't have forests, had a forest fire in 2021. Yeah, in the Kitikmeot. So we have actually declared an emergency in Nunavut because of a forest fire. There have been severe storms. Joe Haven had a state of emergency this year that was prompted by a severe storm. Equipment failures of water and wastewater treatment plants will lead to a state of emergency. We've also had experiences with contaminated drinking water. We've had fires at critical infrastructure. We've had plane crashes, unfortunately, and yes, we've had COVID. So the Emergency Measures Act is what governs in these situations. It is administered by Community Services. Some of you may not have realized, but we had a government reorganization almost exactly 1 year ago. So the Department of Community and Government Services and the Department of ED&T, Economic Development Transportation, have been split. And we now have the Department of Community Services and the Department of Transportation Infrastructure Nunavut, or TIN. And CS is responsible for the Emergency Management Office. And of course, municipal governments have a role under the municipal states of emergency. And for a territorial state of emergency, the orders made by the Minister of Community Services, it lasts 14 days, can be renewed, and it can affect either all or part of Nunavut. Typically, they start at the community level, but they can be declared territory-wide. And the minister's powers during the emergencies, I'm really going to stick with the first bullet on this one because that's generally where we stop. Generally, a state of emergency allows us to speed up procurement, to get in supplies and emergency equipment, to get personnel in to fix the sewage truck, to fly in bottled water, to bring in the resources that we need, and it really rapidly makes procurement faster. It also sometimes is a precedent to seeking federal assistance under federal legislation, is that we have to have a state of emergency in place. We also have the other powers on the slide. We don't usually end up having to use them. We did have to commandeer a building once, but that's a whole other show. For a state of local emergency, declarations made by municipal council. So Joe Haven most recently declared a state of emergency. It lasts for 7 days, but again, it's renewable. The Minister of Community Services has the power to cancel a state of local emergency or to convert it to a territorial state of emergency. And declaration of a territorial state of emergency automatically cancels a local emergency. And again, it can affect either all of a municipality or part of a municipality. In my experience, it's usually for the whole community. So the declaration has to include the nature of the emergency and the part of the community where it exists. And skipping right ahead to the Public Health Act, this is, of course, ministered by the Minister of Health and the Chief Public Health Officer. And the Minister makes the declaration of a state of public health emergency on the recommendation of the Chief Public Health Officer, or CPHO, but the orders themselves are made by various officers, starting with the Chief Public Health Officer, but environmental health officers or medical health officers appointed under that act can also make certain orders. So for a public health emergency, it requires an occurrence or imminent threat that poses a serious risk to public health and includes disease outbreaks in either humans or animals, pandemics, water and sewer system breakdowns, chemical spills. We've seen 3 out of 4 bullets. And a declaration of public health emergencies made by the Minister of Health. Again, base period is 14 days. It is renewable. Of course, remember with COVID, we declared it in March of 2020 and lifted it in April of 2022, but we had to renew it every 2 weeks. The declaration must be published in the Nunavut Gazette, which I know at least 2 of you on this chat read every month. The rest, why not? And it can affect either all or part of Nunavut. The CPHO's powers, are quite sweeping. They're set out in Section 41 of the Act, but they can include everything from authorizing qualified persons to render aid and assistance, to restrict movements, to enter into agreements with other governments, to, again, commandeer the use of buildings, which we did for vaccination sites, to restrict travel to and from Nunavut. We're going to be talking about that a lot today, and as well any other measures reasonably necessary. So CPHO orders must be made in writing. They do not have to be published in the Gazette because they're not statutory instruments, but they do have to be published in all the official languages. And typically during the pandemic, you'll remember we had the daily or regular media conferences where they were explained in real time by the minister and by the CPHO and provided in the official languages that way, as well as published on a dedicated website. And of course, there's overlapping federal jurisdiction, because it wouldn't be Nunavut without a federalism problem or challenge. So territorial laws of general application apply throughout Nunavut, including federal land and institutions, except where there's a conflict with federal law. And in a lot of cases, there's different aspects of the same issue are covered by different levels of different branches of government. And of course, during emergencies, the courts, the legislatures, they're separate branches of government. They have power to control their own process, the power to make their own rules. So during COVID, all of the orders, if you go back, and I know you want to, if you go back and read all of our previous orders, you will notice that we always excluded the courts because the Chief Justice was making rules. He had already covered the field and generally typically followed advice from the CPHO. Same as the Speaker of the Legislative Assembly was making his own rules. So we exempted just because we didn't want to have a division of powers fight and a separation of powers fight during a pandemic. So with that sort of framework in mind, I think we can move on to our next section, which is on our charter and other considerations.
Right. So I actually think that we should just perhaps go straight to the cases.
Sure.
So as you can imagine, a lot of emergency powers that John has talked about and that are available through other legislation, federal legislation, they're quite sweeping and they can impact charter rights. In fact, the federal legislation on emergencies acknowledges that in the preamble. So what have courts done after governments make decisions in emergencies? And to me, it's quite fascinating. There's the decision that I want to start with is, for the sake of today, I'll call it the Canadian Civil Liberties Association case. It's also, you'll see previous decisions, it's the Frontline Nurses case, but it's essentially the series of reviews, judicial reviews, that were brought by a number of parties seeking to judicially review the federal government's declaration of an emergency in 2022. So that's what we're going to start with. We're going to talk about the case. The decision from the Federal Court of Appeal was issued just a few months ago, and it made in, I think it was January, and I'm holding it here. It's a very lengthy decision.
185 pages.
185 or 100, it depends on how you print it, but yes, 185 pages, and it's very comprehensive. It has a lot of really interesting contents, and I'm happy to have a discussion if anyone has any questions about any of it, and if I can't answer it, I'm happy to follow up, because it's a really interesting decision. In part for me, and I think for other lawyers too, because the courts have reached a different conclusion than Justice Rouleau did in the Public Order Emergency Commission. And we're going to talk about perhaps why they ended on a different conclusion. John's then going to talk about the Taylor case and the Evely case. And then I'm going to briefly talk about the Interlake Reserves case. And you'll see the citations for each of these cases in the slides. So starting with the series of decisions with respect to the Freedom Convoy protests. I'm sure that everyone who's on this call is familiar with it, even though this is something that was happening in Ontario. It was a significant event and was in fact right across Canada. I don't think that you had any protests up here. So what are we talking about here? We're talking about an Emergencies Act that was enacted in 1985. I think it came into force a few years later. And it replaced the
War Measures Act.
The War Measures Act. And what's really important, and it was important in the decision at the Federal Court of Appeal, is that The declaration of an emergency, a public order emergency, is set out here in section 17. There's some important definitions in section 16, but the legislation is very prescriptive about what an emergency is, what a public order emergency is, and what it has to specify. And this is really important, although there's a lot of discretion, and there was an acknowledgement by all the parties and by the court that this is a discretionary decision, whether or not there's an emergency. The legislature, in contrast to the previous legislation, was very prescriptive about the requirements for an emergency. And for lawyers who practice in administrative law, it's really interesting how the court in this case ended up saying that even though this is a discretionary decision, because the legislation very carefully prescribed the requirements, in essence, there's only one answer. I always find this really interesting when we look at administrative law and judicial review, and it's supposed to be a range of reasonable results, but in this case, they landed on there's only one reasonable result. But in any event, so this is what the test is for a public order emergency. So what happened? I think people are pretty familiar with the history of the protests, and it happened relatively quickly. But I've laid out some of the timeline to kind of give you a sense of this. The first presence of the protest really was in Ottawa, and then extended to some border crossings across Canada. The convoy by February 8th to 10th was very significant, as you would have seen in the news. And it's notable, many of the decisions note this, that almost 25% of the vehicles that were in Ottawa had children present. The same was true in Windsor and other border crossings. And so it made it very difficult for police, or that's one of the reasons why police said that it was difficult to clear these blockades. The Prime Minister by February 10th was convening a meeting with what's called the Incident Response Group. That group met several times before the proclamation of an emergency on February 14th, 2022. By February 11th, Ontario declared a province-wide state of emergency. The various municipalities that were impacted also at various times declared municipal emergencies. And perhaps like in Nunavut, the types of powers that municipalities have when they declare an emergency it's not very significant. They can't do that much with them. Is that true here for the municipal declaration?
They're much more limited in what the minister can do.
Okay. So by February 13th, there were also injunctions that were brought. I was involved in the one in Windsor. There were injunctions that were brought under municipal legislation to get injunctions to clear the infrastructure. By February 13th, the Ambassador Bridge blockade was cleared, but the declaration of emergency was the following day on February 14th. February 23rd, the proclamation was revoked. So this, by legislation, the Emergency Management Act, it's not just the Emergencies Act, actually requires an inquiry. So the minute that the proclamation was made, the government knew that they would have to do an inquiry. And so the timeline is very tight. It's very quick that they have to issue their conclusions. And Justice Rouleau was the commissioner in that case. The report is fascinating. I think it's a good read, and it's available on the website still. And Justice Rouleau, while making a number of caveats about the limits of his role as the commissioner, the limits of the authority of the commission, concluded that Cabinet was reasonably concerned that the situation it was facing was worsening and at risk of becoming dangerous and unmanageable. And he found that the decision to invoke the act was appropriate. I think it's interesting too in the report that the commissioner he took some time discussing whether or not it was his role to comment on whether or not it was appropriate, the declaration of emergency, but concluded that it was consistent with his mandate, but made it clear that it was the court's role to determine whether or not it was lawful. I also have included here the link to the federal government's response. So they were required a year later to say what they've done in response to the recommendations that were made by Justice Rouleau in his report. And you can see they were a bit late. They did respond. Okay, so then what happened? A number of different parties brought judicial reviews of the decision to declare an emergency. And it made it first to the federal court. And the federal court high level, concluded that it wasn't reasonable. So the court was asked to review the decision both on an administrative law basis, on a judicial review, and the courts both concurred that the standard of review to apply here is reasonableness. And the federal court said it wasn't reasonable. They also were asked to look at it from a charter perspective, which I'll get to in a moment. But really, the focus of the analysis is on the reasonableness of the decision. And I think paragraph 370, and so you can imagine how long the federal court decision is. It's very lengthy as well. I think this paragraph is really interesting, that the court said, at first, the court was leaning to the view that the decision to invoke the Emergency Act was reasonable. And I think it's also really notable that, if you go on and look at the discussion around this, the court really commended the interveners and kind of acknowledged that despite the excellent efforts of the Attorney General's lawyers, that the submissions and the legal argument on behalf of the interveners really swayed their decision. And so ultimately landed on the conclusion that the decision to issue the proclamation doesn't bear the hallmarks of reasonableness as established in Vavilov: justification, transparency, and intelligibility. And it wasn't justified in relation to the relevant factual and legal constraints. So really went back to the test, and I didn't give you the test or the definitions in section 16 of the Act, but was really tied the federal decision to the clear constraints that are established in the legislation. And all of these arguments were made at the Public Order Emergency Commission, and Justice Rouleau landed on a different result. Really, really interesting decision. I have read much of the federal court decision, not all of it given the length, but really interesting discussion about how they could land on this, even though there is wide discretion, how the court could still say that this wasn't reasonable, particularly in the light of the fact that a different judge in a different context found that it was reasonable. In fact, he didn't use the word reasonable. He was careful not to use it, but was appropriate. So what did the federal court do in their lengthy decision? They've essentially upheld the federal court's decision. In this kind of review, the Federal Court of Appeal can actually just substitute their own decision for the federal court's decision. And they did their own analysis, but spoke with support of the federal court's decision throughout. So high level, the Federal Court of Appeal upheld the federal court's finding that the use of the Emergencies Act was not justified. The decision to invoke the Emergencies Act was unreasonable and ultra-virus. The regulations, which imposed certain requirements, infringed freedom of expression. And the order that had to do with collecting people's information with their bank accounts was infringed Section 8's right against unreasonable search and seizure. So here, what did the court say? There's only deference once the requirements of the Emergencies Act are met. So quite interesting. Just as a note, there's more perhaps to be said on this case. The federal court or the federal government did in fact seek leave to appeal from the federal court's decision. And as far as I can tell, based on the Supreme Court website, it's still under consideration, and a number of applications for intervener status have been filed.
So moving on to Taylor, and full disclosure, I was counsel for the Attorney General of Nunavut on this matter. We intervened along with 6 other attorneys general, and we felt we had to, because this was a challenge to Newfoundland and Labrador's COVID-19 travel restrictions from the early part of 2020 in the public health emergency. And Newfoundland's Public Health Act and the powers of their Chief Medical Officer of Health are very much identical to ours. Nunavut's Public Health Act is among the newest in Canada. It came into force just in the nick of time in January of 2020. Newfoundland and Labrador's legislation is modeled on ours. So we felt we had to, because we had travel restrictions, as many of you will remember. We had to go through our 14-day isolation to get into the territory unless you qualified as an essential worker or qualified as an exemption. Those restrictions were enforced from March of 2020 through to they dwindled down once people started being vaccinated, but they officially remained in place for the most vulnerable travelers until the end of the public health emergency. Newfoundland and Labrador changed theirs, but in the early days, they restricted access to the province to residents. And Kimberly Taylor was a Newfoundlander by lineage, but she was a resident of Nova Scotia. And she was trying to get into Newfoundland because her mother was very ill, and then she subsequently passed away. So she tried to get into Newfoundland twice, once to be with her family before her mother died, and once to attend the memorial service. And she was denied in both cases. And she was bankrolled by the Canadian Constitution Foundation, or Canadian Civil Liberties Association, bankrolled her defense. This was challenged in the Newfoundland and Labrador Supreme Court. The Chief Medical Officer of Health's orders were upheld. The Court of Appeal gave it a pass because by the time it hit to the Court of Appeal, pandemic was over, or the restrictions had been lifted, and said it's moot, we're not even thinking about it. Supreme Court of Canada agreed to hear it, and because Newfoundland and Labrador's Attorney General and the parties, the Canadian Civil Liberties Association and Ms. Taylor, all said this, there are going to be other pandemics. We need decisions and we need discretion on this. So what's really interesting about Taylor, it is the first challenge to Section 6 mobility rights in Canada that have nothing to do with chickens, eggs, or lawyers. Because if you remember all of our mobility rights cases, there's not a ton of mobility law cases in this country, challenges to Section 6, and they've been generally about professional mobility of lawyers and the ability to sell chickens and eggs and dairy products in other provinces. This is the first time the Supreme Court actively looked at the ability of Canadian citizens and permanent residents to move about the country, and an analysis of Section 6.1 and Section 6.2 of the Charter. We could fill up the rest of the afternoon on the analysis, and we're not going to. But what's interesting for us is that Nunavut's position on this, which we've been taking throughout the entire pandemic, was that the French version of the Charter was clearer. That it included 6.2, Section 6.2 includes the right to travel throughout the provinces without any reason to want to move there. Whereas the English text sort of implied you had a right to move there, to take up residence. But there was just a casual, independent right to travel. And for those of us who live in the North, having a constitutionally entrenched ability to travel makes a ton of sense, because we have to travel to other places in Canada to receive dental and medical appointments and MRIs, and to see our families. And if you're Inuit, to exercise your rights under the land claim. And under there are ways that we need to move without having to physically pack up everything you own in a U-Haul and take it there. Like, you're coming back, but you need an ability to go. And in the era of climate change, and look at what happened in our colleagues in Yellowknife, which we're going to talk about a bit later, where they had to evacuate an entire city, and they all had to get in their cars and drive to Alberta. So this kind of ability to have entrenched mobility rights was very important to us. And I'm happy to say that the court, both the majority and the concurring decision, lifted different paragraphs of our factum and accepted our analysis. And that's an analysis that the Nunavut Attorney General's office had been taking since 2020. I shamelessly suggest you go and read our factum. It's online on the Supreme Court website, but also the Supreme Court decision. We've got the link on the last, with the sites there, you can look it up. It's another barn burner of a 206-page decision, but it is fascinating. It was, and again, it's not every day you get to participate in a charter decision. So Taylor's important for us from a public health perspective because it upheld our ability to have travel restrictions as part of our arsenal when it comes to doing pandemics, to restrict travel within Nunavut, but also entry and access to Nunavut in future pandemics. And we can have limited restrictions based on your residency. And for the record, Nunavut only had strict Nunavut residents only rules from March until June of 2020, and after that we dropped them. But it was a time limited thing. But any restrictions on mobility you do that will affect Section 6 mobility rights are going to have to pass the Oakes test. There was an argument which was not accepted by the court. This is the last thing I'll say about Taylor, is that the lower courts had picked on something. It's a concept of environmental law, which is more Jen's area than mine, but we applied it during pandemic a lot. It's the precautionary principle. It's what happens when you're legislating in a vacuum where you don't know what's happening. It's a rapidly changing situation, and you're trying to come up with a sensible set of laws. So you take a precautionary approach and you adjust later. And the lower courts, Justice Sawson in an Ontario decision about the churches that were having like live outdoor church services, like I think it's Freedom Bible Church versus Ontario. Justice Sawson endorsed the precautionary principle. Supreme Court of Canada said no. You don't add. They did not want to add another layer to the Oakes test or replace the Oakes test. They said the precautionary principle is an interesting thing for the decision maker to use when they're making their decisions, but you still have to pass Oakes scrutiny. So that's we had argued in favor of a precautionary principle being put in. That part of our argument wasn't quite as accepted as the Section 6.2 stuff. But anyway,
different discussion about.
But I digress.
The use of precautionary principle in environmental law too, but another time.
But I kind of knew that you could tell from the room that wasn't going to be accepted. That they didn't want to reopen the Oakes test after 30 years. They didn't want to do that. So now briefly on Eveleigh, because this is hot off the presses. And as a native Nova Scotian, it was something I lived through last year. Nova Scotia had a worst drought they'd had in 30 years, didn't have rain for 2 months. And our forests were tinder dry and were just one bad day from having a province-wide forest fire. So the province enacted sweeping restrictions and including fines and barriers to entry to access to most woods, most forests in the territory, or in the province, I should say. Eveleigh was bankrolled by the Canadian Constitution Foundation. He broke the law on purpose on the first day in view of 3 conservation officers. This was a challenge. This was an FU to the government saying, you're violating my rights for no reason. I'm going to get a ticket and I'm going to challenge it. And he did. And there's a decision which is, it's brief. It's only 17 pages for your reading pleasure. And it's surprisingly poetic in its analysis. I'll say that about what the difference between a forest and the woods. It does actually opine on the woods, distinguishing the woods from the trees. Ultimately, the Justice of the Supreme Court of Nova Scotia, so that's the lower court in Nova Scotia, said the province had overstepped. The minister never considered the charter, never considered mobility rights, never considered impacts on anything related to the charter. When he made his analysis, it was strictly based on what the forest fire risk was and based on scientific information and on weather reports and on past practices, but hadn't considered that kind of impact. And there was a great deal of pressure politically to get something done and to put in a measure that people would actually comply with, because the lower measures hadn't been working. So that decision was found to be unconstitutional. It was struck down. I strongly anticipate the Nova Scotia Attorney General's office is preparing a notice of appeal as we speak. So stay tuned. But right now, the lower court struck it down, said it was overreach on the minister's part.
Okay, so I'm going to talk about a case that's a little bit older than the ones we've been discussing. It's the Interlake decision out of Manitoba. So this case is interesting for a number of reasons. It brings in an environmental emergency, but preventative action on the part of the government. So here, there's the decision of the Court of Queen's Bench of Manitoba takes some time to emphasize the risk to Manitoba of fires. And what the Manitoba government was planning, this Lake Manitoba and Lake St. Martin Outlet Channels project, which is, depending on the reports that I've reviewed, multi-hundreds of millions of dollars projects or a multi-billion-dollar project, but a very significant project that was undergoing different levels of environmental assessment at the time of this judicial review. So what happened is that some of the affected First Nations who were impacted also by the flooding there argued that this massive project would cause environmental damage and also would impact their rights and their treaty rights or constitutional rights. And they brought this judicial review to challenge the approvals, not the overall project, but I think it was a permit and a license for preliminary clearing and permitting. By the time this case made it to the court, the work under the permits had already been done. And just further to what John was saying about this, there was an argument here that this judicial review was moot. The work had already been done. But what the court found was, under the factors that you apply under the leading case law, that there was value to reviewing one of the permits, even though the work under it was already done, and in part because it's in the context of this massive project that was going to be subject to a number of different licenses and approvals. And really important to have some comment on the relationship between the proponents and the First Nations that were impacted by the project. So what did they do? The court here found, in one case, they did dismiss one of the judicial reviews, but the permit for a right-of-way on Crown land that was related to the project, the court found that the provincial government breached its duty to consult First Nations regarding that permit for right-of-way. And the court criticized the Crown for relying heavily on a consultation report prepared by Manitoba Infrastructure that had been prepared without giving Interlake, the First Nations applicant here, the opportunity to review and respond to it. So I suspect a result that many on the call would perhaps expect, but part of this in the context of environmental law and the regulatory approvals process is that there's so many different approvals that are required as you go through the process. So this judicial review was really about a couple of preliminary steps in this big project. And the court saying here very clearly, you've got a duty to consult at each of these stages. And even long-term preventative measures can engage consultation obligations where there might be negative impacts on Inuit old lands and Inuit rights. Okay. I also wanted to mention here a couple of things about the decision. I think it's a pretty clear and well-written decision, not the longest one we're talking about today, but 74 pages. And it reminds us a few things about administrative law that I might as well take an opportunity to remind everyone. So we talk about standard of review. In this case, the court has a couple of nice tight paragraphs on standard of review, on judicial reviews involving the duty to consult. So when it comes to procedural fairness, I think maybe the Supreme Court's going to say a little bit more about this, but the court's, it's essentially correctness. Was it fair or not? If you're going to judicially review something on the basis of procedural fairness. And then when it comes to the duty to consult, there is the question of, is a duty to consult triggered, and what's the scope and content? Oh, I think somebody needs to mute their audio. Anyway, okay, so when it comes to whether or not there is a duty to consult and the scope of that duty, that is reviewed on a standard of correctness. And then whether or not the consultation was adequate, then that's reviewed on a standard of reasonableness. So the Vavilov reasonableness standard. So just, I like the reminder that it's very well established in the case law now, that the issue of whether there is a duty to consult is the courts can review that at that higher standard of correctness. Okay, so we have included in the slide deck a number of other decisions in various courts across the country where courts have reviewed the exercise of discretion and the scope of powers when they're asked to review government decision-making in emergencies. And I thought, I don't know at what point we're going to open this up to questions, but have a discussion about what we're seeing in trends in the case law and how our courts reviewing those decisions.
So I think mootness is going to come up in every one of these decisions because emergency decisions are by their very nature made very quickly. And they are quite often made very on available facts at the time. And there's always going to be a level of politics as well because when you've got political elected ministers making decisions informed by public servants, there's an element there that's going to be coming in. So, I mean, Porter in Nova Scotia, which is the first we have on the slide, is this never-ending highway development project in Windsor, Nova Scotia, birthplace of hockey. and giant pumpkins, but that's again a whole other show. It's a highway twinning project that has been stalled forever because there's this artificial lake that the province established back in the 60s called Lake Pisiquid, which there's this never ending spat with the local First Nation who want it drained to restore the waterway so their fishing rights can be properly maintained. The town and the province say this lake is very useful for firefighting and forest fires. And that's what the minister has been using to renew this state of emergency every 2 weeks, for every 2 weeks. It finally hit to the Court of Appeal. So it's one of these things that it's this never-ending story, but it shows you the caution that these emergency declarations, which are supposed to be short-term, can go on for years. And that's not necessarily what the legislatures had in mind when they brought in those sorts of emergency powers. So you'll see in other legislation, certainly at the federal level, that there's a review by Parliament after so many days. So there's a review by the legislature after so many days. I think you'll see that post-COVID getting built into as laws get amended, because SARS had been our longest pandemic prior to COVID, and it was over in a couple of months. COVID went on for almost 3 years.
Right, and I think we look at the cases, I think that we were discussing this as we were preparing for this CLE, that when you look at decisions that are closer to the pandemic or made during the pandemic, perhaps there's more deference on the part of the court to this discretionary decision making. When they have more time to consider and the emergency is over,
we're past the "oh God, we're all going to die" phase. Because if you look at some of the early decisions in COVID with healthcare workers and masks, or with mandatory vaccinations, if you look at what the labor arbitrators and the courts are deciding in the early days of those decisions, it skews very fit in the minister's favor or the public health favor. The longer the pandemic went on, the more your rights started coming back into the equation.
And I think about the Rouleau Commission, which was immediately after the declaration of the emergency. A lot of the evidence from there was some dispute, but some of the applicants brought the evidence from the Public Order Emergency Commission, which was extraordinary, right? They had testimony from most, if not all, cabinet members who were involved in that decision, including the Prime Minister. And they were able to convince the court to allow the testimony and evidence that was before the Public Order Emergency Commission to be used for the court's review of that decision, which of course now has been years after. And interesting that years after there a lot more scrutiny on a very discretionary decision. And I'm not going to comment. I don't have an opinion on whether or not it was a reasonable solution, a reasonable declaration, but very interesting to me that the courts have come to a different conclusion than the commissioner. So what do we see from these cases? We see that the courts, particularly when they're looking at this from hindsight, they scrutinize the language of the legislation very carefully, and they think about what exactly is the scope of powers that were delegated that the discretionary decision maker is using. And then also that an error in a decision is not necessarily sufficient to justify quashing a decision, right? So back to the reasonableness, right? It's not about whether they were right or wrong, it was whether or not it was a reasonable result.
And reprehensible conduct on the part of a decision maker is always going to get thrown out, no matter how justified it may have been at the time. If you send in the hired goons and you didn't have the right to do that, that's no court in the land is going to say that was passes the Oakes test.
Why don't we talk a little bit, have a bit of a discussion about the Indigenous perspective. John and I had the benefit of being involved in the Osgood
certificate in emergency law. Jen was we were both involved. Jen was on the faculty and I was a student. Well, then we subsequently did a CLE together.
Yes. Was it a year or two ago? Yeah. With an excellent professor from out west, Jocelyn Stacey. And she writes a lot about when we think about jurisdictional issues in Nunavut, it's a bit different than what Jocelyn Stacey is thinking about. But she's thinking about interjurisdictional issues when it comes to Indigenous governing bodies. Jocelyn Stacey was also, I can't remember what they called it, but she was somebody who wrote a paper for the Public Order Emergency Commission. and she focused on the interjurisdictional issues. In that case, thinking about how complicated it is that you've got your municipal, your provincial, and your federal areas of jurisdiction in an emergency. And in an emergency, you need to be able to move quickly. But when you have overlapping areas of jurisdiction, and then you have municipalities and Indigenous governments that aren't recognized in our Constitution in the same way or at all, it certainly becomes quite complicated in the decision making. I don't know if you want to say anything about her papers. I've put one paper here. It's not the
and you'll
only
also
one.
see there's an obligation, there's an inherent right of self-government that's been recognized with First Nations, and when they want to make laws that are different from what the province wants to respond to the same emergency.
Mhm.
And every wildfire season in British Columbia, this is an issue, an ongoing issue. There's been legislative amendments in British Columbia that involve more consultation or more of a role for First Nations governments. We'll see how that plays out. Now, of course, in Nunavut, we worked very closely with NTI during the pandemic. They don't exercise a governance role. That we have a territorial public government, but we didn't do anything big without talking to them first, because it's better to have the largest land claim organization on your side, or at least supporting you quietly, than being against you on something. So, but you'll see this more and more, particularly with climate-related emergencies or with your wildfires and your floods. And I think you're going to see that more often. I will just plug Professor Stacey Stuff. She's an excellent writer, among other things, but her presentations were fantastic in our certificate course. And anyway, so I recommend ICRQ. She's at University of British Columbia, faculty of the Peter A. Allard School of Law at the University of British Columbia.
And then she gave a perspective at the Public Order Emergency Commission that was really unique. The Emergencies Act is federal legislation, and that whole commission was focused on a federal act. But in practice, I think it's a bit different in Nunavut, where there's, I think that the GN is very engaged in these things. But emergencies across the rest of Canada are first responded to by municipalities.
Yes.
They do the bulk of emergency management. But when it comes to interjurisdictional cooperation over emergency planning, it happens at the federal and the provincial and territorial levels. And I don't know, maybe you see municipalities at the table, but a common complaint I hear from municipal clients in the South is that they're not engaged in emergency planning and coordination at the same level when they're the ones doing the initial response. And the kinds of emergencies we have, and maybe this is a good segue to talking about Yellowknife, because I actually don't know. Was it first a municipal emergency, and it escalated quickly?
Territory-wide
right away.
State of emergency due to wildfires. And we put sort of a compare and contrast, because our most recent local state of emergency was in Johaven, where severe weather caused problems at the power plant, caused lack of power. And of course, when there's no power, the pumping station, getting your drinking water doesn't necessarily work. The water has always been safe to drink. I'm not saying that because I work for the government. I'm saying that because the chief public health officer tested it and said it was fine. But getting that water delivered was a challenge. Getting supplies delivered in a big freeze up. So the territory, both the municipality, then the territory, declared states of emergency to bring in bottled water and to bring in supplies. That state of emergency was over in a matter of weeks. There are still long-lasting effects where there are repairs that have to be made this summer and that sort of thing. But Yellowknife is the first time you've seen a territorial capital city evacuated. That's 17,000 people evacuated. And what it shows across the three territories is that we do not have the carrying capacity to absorb an evacuation of any one of our communities to another community in Nunavut or in Northwest Territories or Yellowknife or in the Yukon. We're inevitably going to require aid and assistance from our friends in the provinces and our neighbors in the provinces. And this federation is predicated on us all getting along, particularly in a time of crisis. But the fact that we have the Taylor decision and we have other things like that entrenching rights to mobility mean if there are some plane loads full of internally displaced people within our own country moving to get away from an emergency, which you see in the provinces every fire season.
Yes.
when people from northern Saskatchewan, northern Alberta, I mean, Fort McMurray had to be evacuated to another part of Alberta.
Yes.
The First Nations communities in northern Manitoba had to be evacuated to Winnipeg. But if you had to evacuate Rankin Inlet, they're not coming to Iqaluit.
Mm-hmm.
They're also going to Winnipeg or Churchill or somewhere in the south. So we have to maintain those lines of interprovincial and territorial, federal, provincial, territorial cooperation just to make sure that in a crisis we would be served.
Mm-hmm.
So we are coming up on time. We've got about 10 minutes left, and we did promise some question time for Q&A. So Rebecca, can you open the floor?
Sure. Do we have any questions? Thank you so much, guys.
Or comments. Does anyone have any comments? Jump in. I do love that we can do this virtually, but it is easier to pin people down when you're in person.
And if you are the type who is uncomfortable asking questions in front of the entire class, or you think of something 20 minutes from now, our email addresses and phone numbers are on the last slide of the presentation. I think you know where to find both of us, and we'd be happy to entertain an email or two.
Agreed.
Yeah, well, I thought it was an excellent presentation of a very current area of the law that we read about in the media a lot of. Very timely, and of course the wildfire situation isn't going away anytime soon in the rest of Canada. That's an issue that doesn't concern Nunavut, however, but the work that you did in presenting this morning was very useful to all of us, I'm sure. Thank you.
Thank you.
Anyone else? Well, you know, I think one of the things that I think about now is what have we learned? If you're giving advice to government, let's just say in the abstract,
which I do.
Say you're giving advice to government and they're making a decision in an emergency. I always think when I work with some municipalities, keep records as you go. One of the things that we're talking about these cases, that there's a record that's produced so that the court can review the decisions. And so I think that from the outset, if you are able to
Rule 591
yes
of our Court of Justice, you have to be able to produce as the decision maker or counsel for the decision maker, you have to produce the entire record that was before the decision maker.
Mm-hmm.
And the better your record, the better chance you're going to have of at least the court deciding in your favor, or at least knowing why you made the decisions you made. And with us, where we have constant turnover in the north in positions, getting those records captured or getting affidavits or getting statements as soon as you can is very useful. The other thing that I notice that comes out of what we learn is all the aftermath that we find out what happens after a disaster, where our legislative gaps are on things you don't think are emergency law.
Mm-hmm.
That, for example, most insurance policies don't cover forest fires, don't cover overland flooding. You've got insurance adjusters denying claims because there was no one in your house when the pipes burst, except no one was in your house when the pipes burst because the city had been evacuated.
Oh, really?
So there's a number of things that come up after the fact that you don't realize, oh, this might be something we should fix when the temperature has simmered down a bit.
Yeah.
So as someone who works advising government, that's my day job, there is the never-ending list of law reform projects you could do. Even as something as simple as recognizing the ability for us as lawyers to notarize things electronically.
Right.
Ontario changed its regulations to make it possible. We never did.
Yeah.
We probably should.
I've noticed that.
So I'm saying this because my department's responsible for that legislation. But anyway, it's the stuff you learn during it. But in my experience, having worked in this space I've been with the GN almost 16 years. I've advised on a lot of emergencies over the years. For the most part, I don't have to have that lecture or that talk about, well, you really have to do the minimum and you can't, like, because our decision makers know that already. They don't need to be told, we don't want to trample over people's rights.
Mhm.
They want to do exactly what they need to do, and that's it. Now, there still should be courts, and still should be judicial reviews and checks and balances, because trust us, bro, is not a standard. But I am content as an advisor to government that when we give advice as an attorney general's office, we get listened to.
And one of the things that I've been watching the Rouleau Commission for a number of reasons, self-interested, having been a part of it. But there were, I don't know how many, 40 something, many recommendations that he issued. And one of the terrible things about emergencies is that during the emergency, one of the things that always comes up were you prepared? Did you plan for the emergency? And did you practice? Right? And at municipal levels, the emergency departments there, they do that. They practice. We practice fire drills in schools. But for things like pandemics, there was a study done. There was an inquiry into the SARS pandemic, and then there have been some with respect to the COVID-19 pandemic. And what they find is, as soon as the emergency is over, it's very difficult to maintain the intention and to put the resources into emergency preparation and training and planning when you have another emergency or another crisis that you're facing as a government. So I think it's perhaps on all of us to put some pressure on, so that we're not left the same way we were with COVID, with not great planning, despite the fact that we'd experienced SARS before.
And that's what was interesting about it. And again, we've got a few minutes left, and I could go on about this all day.
Mm-hmm.
But I've been working in this space the entire time I've been a lawyer, because my first summer gig was with the New Brunswick Department of Health. And part of my role was helping the Pandemic Preparedness Steering Committee, because that report, the Royal Commission in Ontario, had just come out about SARS. And all the provinces and territories and the federal government were talking about what legislation do we need, and what plans worked and what plans didn't. And that's where the Quarantine Act came in. That was a direct result of the SARS pandemic. But also, all those temporary hospitals and the big tents that went up in triage centers, those were plans that were developed post-COVID,
Mm-hmm.
or post-SARS,
Yes.
that helped us in pandemic. But we had a pandemic preparedness plan in Nunavut in March of 2020, but it was for SARS.
Right.
It wasn't for this kind of virus.
Yes.
So we had to kind of throw parts of it out and
Mhm.
start again, because we didn't have the testing capacity to do the track and trace that we were supposed to be able to do. So, but yeah, the fatigue sets in that once a public health emergency is declared over. I'll just give you an example. We declared the end of the public health emergency on April the 11th of 2022. 2 days later, I was landing in Bermuda and sitting on a beach, because I just didn't want to think about the pandemic for a week.
Mhm.
I needed to start my recovery from that. There was a lot of that said, this is done, we're over. Our chief public health officer went back to become an emergency room doctor because it was less stressful than being CPHO.
Mhm.
So there have been a lot of changes since then, but it's keeping up the momentum in the panel and on the planning.
And the planning,
One thing
yes.
that has happened, I think I'll end with this, is that the provinces and territories are better at talking to each other on this, that we have a regular FPT, Federal Provincial Territorial meeting, where we talk about this.
So now we want to include the Indigenous governments and the municipalities too.
Yes, of course. We'll need
All
a
right.
bigger table.
Yes.
So with that, thank you very much for your participation. We'll hand it over to Rebecca for the...
Well, thank you very much, folks. And if anybody didn't hear the whole thing, again, the recording will be posted online. And thank you so much again to Jennifer and to John for sharing your time and your expertise and your wisdom. And enjoy the day.
Thank you.
Thank you, everyone.
Bye.